Do you hear me well? All right. So this is the sort of part of my international course on campus, and I thought that it would be good for us to make it open to the public on campus, so that those who are interested in listening to the special lecture by former judge of Jin-Hyun Paik, today, right? My name is Professor Jung Seo-yong. I'm a professor here at the Division of International Studies of Korea University. Also, I'm currently the president of Seoul International Academy, which is also another co-hosting organization for this special lecture today. Before I introduce, Judge Paik to all of you, just giving you some sort of the background of today's special lecture. As you may know, that recently geopolitical situation in the world has become very serious enough. So, having more possibility to have disputes and possible other issues between among the countries, in the sense that dispute settlement mechanism under the UN system has become more important than before. And then in this context, the Republic of Korea has produced actually various in various areas with judges of various international tribunals, but except the International Court of Justice yet. So this year especially, Republic of Korea has decided actually to run for the election for the available seat in the ICJ, and then Professor Jin-Hyun Paik has been nominated as the official candidate for that position. So before I explain and introduce about the background of Professor Paik, before we formally start, I'd like to invite Professor Paik and our honor of the guest for our brief photo session, and then we can formally start. So, Professor Paik, please come over here.
여기 강 교수님 제 옆에 오시겠어요? 봉 변호사님 옆에 오시죠. 찍으세요.
찍겠습니다. 하나, 둘.
네.
찍겠습니다. 하나, 둘.
앉으시고 제가 소개해드릴게요.
So, as I said, let me just introduce Professor Jin-Hyun Paik briefly. As I said, he is currently a candidate of the Republic of Korea for election to the International Court of Justice for the term 2027 to 2036. So currently, Professor Paik is a senior advisor of the Korean National Diplomatic Academy Center for International Law in the Republic of Korea. Previously, Professor Paik was the professor of international law at the Graduate School of International Studies of Seoul National University before he retired. And also, he was the president of the Sea Lanes Communication Slot Study Group, and during he's chairing that group as well. He was also president of the Korean Council of the United Nations System during the term of 2008 to 2011. In terms of his career at this international dispute settlement mechanism systems, he was the judge of the International Tribunal for the Law of the Sea from 2009 to 2023. During the time that he served the presidency, during the time of the 2017 to 2020 at the International Tribunal for the Law of the Sea later. Professor Paik graduated from the Seoul National University College of Law, so he's my senior at SNL Law. and also he got his master's degree in law from Columbia University School of Law, and then his final degree, PhD, comes from the University of Cambridge Faculty of Law in the United Kingdom. So without any further ado, let us welcome Professor Paik with a round of applause.
Thank you, Professor Jung, for your generous introduction. Good morning, everyone. I'm pleased to be here in Korea University to give special lecture on international dispute settlement. As introduced by Professor Jung, I retired from university approximately 2 years ago. So I no longer teach classes in university. Therefore, it is a very special opportunity for me to be back to campus and give lecture to you, and hopefully to have some opportunity to discuss matters relating to international dispute settlement. I was told that this lecture will continue until 11:45, if I'm not mistaken. So maybe I will speak about less than an hour, and remaining time I will have some discussion with you. If you have any questions relating to this class or any other matters of international law, then I would be pleased to respond to your question or comments. Today I will maybe briefly talk about the international dispute settlement, particularly adjudication as a means of dispute settlement. Then after this, I will probably spend a few times to share my experience related to dispute settlement with you. I will introduce to you 3 cases, 2 of which I was personally involved as how adjudication played a role in settling a difficult dispute between states. But first, let me briefly talk about what is international adjudication. Maybe I need my own text here. International adjudication is, of course, a means of settling international dispute. Here, when I say international dispute, I'm talking about disputes between states, in principle. International adjudication refers to means of settling interstate dispute by a legally binding decision of the third party, usually international court or tribunal, on the basis of international law. International disputes, dispute between states, are an inevitable part of international relations. There is nothing wrong that there are disputes between states. It's really part of international relation because states have different objectives, values, policies, and also resources are limited, and so on. So there are bound to be a dispute or conflict between states with respect to many matters. So there is nothing extraordinary that there are disputes between states. What is important is to settle those disputes peacefully. So peaceful settlement of international dispute, that is really most important. And peaceful settlement of international dispute is a fundamental principle of international law and international relation. This principle is enshrined in Article 1 of the United Nations Charter. Then, of course, how then to settle international dispute peacefully? In fact, there are various means of dispute settlement, both diplomatic means and legal means. So let me briefly overview different means of dispute settlement. Diplomatic means, obviously this is a method of settling or resolving disputes by diplomatically. Obviously, most well-known diplomatic means of dispute settlement is negotiation. When dispute arises between states, the parties to dispute usually try to settle those disputes through negotiation. Negotiation doesn't involve any other party than parties to dispute. In fact, parties to dispute try to settle their dispute between themselves. Negotiation may be the simplest form of dispute settlement. In reality, it is most frequently used forms of dispute settlement. If you look at various places around the world, when there arises a dispute, states first attempt to negotiate with each other. Then, in some cases, negotiation leads to successful settlement of dispute. But in some other cases, negotiation turn out to be short of settling dispute. When parties are not able to settle their dispute between themselves, then they try to seek or enlist the assistance of other states, a third party. So when third party intervenes to settle dispute between the parties, there are many other means of dispute settlement. Those include fact-finding, inquiry, good office, mediation, conciliation, etc. I really don't have time to go through those means of dispute settlement. I'm sure you have had a chance to learn about those different means of dispute settlement. But obviously, all these different means of dispute settlement entail different degree of involvement of third party. For example, you may say fact-finding or inquiry requires a certain degree of third-party involvement, but that degree may not be very intrusive, whereas mediation, not all mediation, but certain type of mediation may involve the quite heavy, intrusive involvement of third party. Conciliation is almost similar to adjudication. Conciliation requires quite a substantial involvement of third party assistance. Really depending on what kind of measures, what kind of means we are talking about, the degree of involvement of third party also varies. Now, legal means once again, you may call it adjudication or legal means. Legal means is a dispute settlement by a legally binding decision of the third party on the basis of law, on the basis of international law. In that sense, it is quite different from diplomatic means. There are two kinds of legal means. First is arbitration. Second is judicial settlement. Historically, arbitration precedes judicial settlement. Arbitration is adjudication which involves the submission of dispute to ad hoc tribunal for legally binding decision. Ad hoc, this is a Latin word, means for this purpose or for this. So ad hoc tribunal is a tribunal created to deal with a specific dispute, and that dispute only. So arbitration is a form of adjudication in which parties to dispute submit their dispute to specific court which was created to deal with that particular dispute. Once dispute is settled, of course, that tribunal, ad hoc tribunal, will be dissolved. On the other hand, the judicial settlement involves a permanent standing international courts or tribunals. So, judicial settlement is adjudication in which parties to dispute submit their disputes to permanent standing court for settlement. So in that sense, there is a clear difference between arbitration and judicial settlement. In both cases, since they are adjudication, they are settlement of dispute by legally binding decision on the basis of international law. So there's no difference in that sense. However, ad hoc arbitration involves ad hoc tribunal, whereas judicial settlement involves permanent standing court. There are certain advantages as well as disadvantages of arbitration and judicial settlement. Now, let me briefly talk about all these different means of dispute settlement. There are different ways to evaluate those diverse means of dispute settlement. However, one way to look at those various means of dispute settlement is this perspective. Who has control over the dispute? Here, there is a dispute between two parties, P1 and P2. Then P1 and P2 attempt to resolve their dispute through first maybe negotiation without the assistance of third party. But then when they are unable to do so, they may consider seeking the assistance of third party. Then third party get involved with the dispute between P1 and P2. Then how much third party would be involved with that dispute. Depending on how much involvement third party will have over that dispute, or if I may put it conversely, how much control original parties to dispute may have over a dispute. You may have a different means of dispute. For example, negotiation. Negotiation, by definition, doesn't involve third party. Therefore, original parties, disputants, have 100% control over that dispute. On the other hand, the other side of this spectrum, the opposite side of spectrum is judicial settlement. Judicial settlement, once parties to dispute submit their disputes to International Court of Tribunal, then they no longer has control over their dispute. Now it's up to the court or tribunal. So here parties have least control over their dispute. So if you look at this different means of dispute, maybe negotiation, third-party involvement is zero, whereas parties have 100% control over their dispute. On the other hand, adjudication may be the other opposite. Parties, in fact, lose control over their dispute and refer their dispute to third party. A third party has 100% control. Then in the middle, you have various means of dispute settlement. Even, for example, mediation is very popular means of dispute settlement, but even mediation, there are many kinds of mediation. Sometimes a mediator play a very elementary role, simply persuading parties, reluctant parties, to enter into negotiation, and that's it. So that is very elementary mediation. On the other hand, some mediators not only persuade parties to enter into negotiation, but also suggest terms of settlement to the parties, and even going beyond that, they put a pressure on the parties to accept those terms of settlement mediator suggested. This is a typical form of mediation in the United States, for example, plays in the Middle East when there is a dispute between parties. United States not only influence parties to enter into negotiation, but also make its own solution to the parties, and even going further than that, influence or put a pressure upon the parties to accept those solutions United States suggested through, giving some inducement such as economic or military aid, or sometimes threatening. If you don't accept these terms, we may stop assistance we have provided so far, and so on. So this is what you call quite active mediation. So even for mediation, there is many different kinds of mediation in terms of degree of involvement of third party and so on. So this is one way to look at the various means of dispute settlement, maybe sometimes parties to disputes are reluctant to submit their dispute to adjudication, arbitration or judicial settlement, even if they were not able to settle dispute between themselves or through diplomatic means, then one can wonder why that is the case. Maybe it is fundamentally because parties may be afraid of losing control over their dispute, or may not have full confidence with the third party, international court or tribunal, or generally states have fear of uncertainty and so on. Now, each means of dispute settlement has its own advantages and drawbacks. Therefore, it is difficult to say in general or in the abstract that one means is superior to another means. It's difficult to say negotiation is better than adjudication, or or conversely, adjudication is better than negotiation or mediation. Difficult to say what is the best means for specific dispute, settlement of specific dispute. It depends on the nature and type of dispute and disputants, and the context and circumstances of dispute. So it is always dangerous to generalize the suitability of particular means of dispute settlement. It really depends on specific circumstance, context, who are the parties to dispute, what kind of dispute we are dealing with, and so on. If I may add one more thing, usually multiple means are employed to settle dispute. If you look at actual cases, those different means are not mutually exclusive. In fact, on the contrary, multiple means are employed. So negotiation and adjudication may be employed together simultaneously. So sometimes in the middle of adjudication, parties somehow came to an agreement to settle their dispute. So this is what you call out of court settlement. Then adjudication may be terminated. That is usually the case in many disputes. Now, let me move to international adjudication. Once again, it has both arbitration and judicial settlement. History of adjudication as a means of dispute settlement is relatively short. For example, compared to negotiation or mediation, which goes back to centuries. But the history of adjudication, as I said, arbitration precedes judicial settlement. The history of arbitration is about 250 years. The first modern form of arbitration started after independence war of United States. That is late 18th century, so it's about 250 years. And its role as a means of dispute settlement has been rather limited. In fact, the number of disputes being submitted to adjudication has not been large, so its role was relatively limited. However, there are certain advantages of adjudication. The most important advantage of adjudication is dispositive. In other words, adjudication puts an end to the dispute within a fixed time frame. In my experience as a judge of International Tribunal for the Law of Sea, in fact, several disputes that have been submitted to the tribunal, ITLOS, we call it ITLOS, International Tribunal for the Law of Sea, ITLOS, are really long-standing disputes. Some disputes have been in existence for several decades. But once parties agreed to submit that dispute to the court, that dispute will come to an end within 3 years or 4 years, So dispute that have been in existence for several decades will come to an end. Of course, then the question is, the outcome is really satisfactory to a party. That is different question. But dispute comes to an end within a reasonably brief period of time compared to the duration of that dispute, which have been 30 years, 40 years. So dispute which have plagued relation between the parties for 30 years, 40 years comes to an end, and the parties may be able to start afresh. They put their dispute behind. They can now start a new relationship between them. That is one big advantage of adjudication. And the second advantage is adjudication is impartial and principled. In fact, adjudication settles a dispute on the basis of law, objective legal principles, rather than parties' respective power, economic, diplomatic, military. So in that sense, adjudication can be an attractive option for relatively small states when there is a dispute between big power and small states. Small states may consider adjudication as an option because adjudication is not influenced by relative power discrepancy between the parties. In fact, I have seen several cases in which small power, small state brought legal actions against big power successfully. This is what happened between Nicaragua and the United States in this very famous paramilitary case. Also, as I will introduce to you, Mauritius also successfully launched this legal action against the United Kingdom and so on. So this is another advantage. Third advantage may be adjudication may depoliticize dispute and reduce tension between the parties. Also, it can buy time. Once a dispute which was very politically sensitive, was referred to the International Court of Tribunal, then maybe tension may be reduced over time. I dealt with this very emotionally charged, politically sensitive dispute between Italy and India, this Enrica Lexie case. And that case was politically very sensitive and a very emotional case. But then once dispute was submitted, then over time, tension was reduced, and this has become depoliticized. And eventually, when we gave a decision, I think it was about 5 years after this dispute broke out, parties were prepared to accept any decision this arbitral tribunal gave at that time. So that's another advantage. Finally, presidential and help prevent future dispute of similar kind. Because adjudication settles dispute based on law, by applying legal principles, it can be precedential. It helps develop international law, and it also can prevent future dispute of same or similar type. Of course, there are some shortcomings, maybe. There are some limitations. Adjudication may be, a lot of people say that it's unpredictable. You don't know what will be the outcome, uncertain, and involves a risk of losing. So for parties' perspective, for a party which cannot really afford losing that case, adjudication may not be a good option. Adjudication is adversarial and potentially escalatory. In many cases, adjudication is perceived or considered to be unfriendly act. So adjudication can even exacerbate existing dispute. I often see such development after start of legal action. So that can be another limitation. Also, adjudicated settlement is not really spontaneous settlement. It is a settlement that was imposed by the third party. So the parties to dispute must accept it. Also, it may not be as flexible as a settlement by negotiation. Negotiation often involves the split the difference type of settlement. On the other hand, this is the settlement by the application of law. So in that sense, it can be, it may not be as flexible as settlement by negotiation. It is rigid. So often these are considered as limitation or shortcomings of adjudication. Obviously, there are no, panacea. Adjudication or any other means of dispute settlements have their strengths or advantage as well as limitation. Now, trends of adjudication. The role of adjudication has considerably grown in the past, I would say, 3 decades, maybe since mid-1990s. If you look at this international legal development, there have been more international courts and tribunals. Now the number of disputes being submitted to international court and tribunal have increased quite significantly. States are now more willing to submit their disputes to adjudication. So in terms of quantity, more disputes are being submitted to international court or tribunal. In addition to that, if you look at the nature or type of dispute being submitted to international adjudication, in fact, many highly complex, politically sensitive disputes are currently being submitted to international adjudication. This is particularly the case with the International Court of Justice. Currently, there are about 27 cases pending before International Court of Justice. So this is really unprecedented level of caseload of ICJ. And in addition to that, if you look at the nature of cases, many cases being submitted to ICJ are very politically sensitive, highly sensitive and complex dispute, right coming from ongoing war or international conflict, such as this war in Ukraine and this war in Gaza, and so on. There are many cases involving Ukraine and Russian Federation. Also, many cases involving Israel, this alleged genocide against Palestinians in Gaza, and so on. These are really highly politically sensitive disputes. Also, there are, dispute between this involving allegation of genocide in Myanmar, this against Rohingya minority. Also, a case involving, this war between Armenia and Azerbaijan, and so on. So today, if you look at the ICJ, many this complex, highly charged political dispute have been submitted to International Court of Justice. Then, of course, one may ask a question whether how to accept this kind of trend, latest development. Of course, we have a distinction between legal dispute and political dispute. Purely political dispute is not really amenable to adjudication. Court cannot deal with purely political question. Then you may wonder, what is political question? Maybe political question is what should be law rather than what is law. That may be political question. But anyway, purely political question may not be suitable for adjudication. On the other hand, many legal dispute involves political motivation, political background, and so on. That doesn't prevent court or tribunal from dealing with that case. So court can deal with dispute, although that dispute has political motivation, political background. In fact, many dispute has political motivation and background. So the fact that certain disputes are politically sensitive, politically complex, doesn't mean the court should be precluded from dealing with that case. What is important is the role of court, the function of court should be confined to legal question, legal dispute only. Usually, if you look at this complex political dispute, which I will deal with quickly, there are certain legal disputes in it, in this broader political dispute. So when court is asked to deal with that legal aspect of broader dispute, court should be confined to that aspect, should not be tempted to go beyond and try to overstep its function. So that is very important. Shabtai-Rosen, this famous legal scholar, once said litigation is but a phase in the unfolding of a political drama. The question is, what is important is international court and tribunal should confine itself to legal aspect rather than trying to resolve this unfolding political drama, and always have to think about whether adjudication can improve the prospect for and can serve the catalyst to eventual resolution of political drama. So that is an important aspect. Now, let me quickly this light is very strong suddenly. What happened?
Because of the net.
Okay. Okay. All right. I try to avoid this light. Today I will introduce to you three cases: South China Sea and this Black Sea dispute between Ukraine and Russian Federation. And this South China Sea dispute is, of course, dispute between Philippines and China. Then finally, I will briefly deal with the dispute over Chagos Archipelago between Mauritius and Maldives. All three cases are politically complex, very, very sensitive disputes. Then legal, this means adjudication has been attempted, and I will touch upon whether this attempt, adjudication, has served or contributed to ultimate resolution of this dispute. I was involved with two of these three cases. I was not involved with South China Sea arbitration, but I was involved with this dispute between Ukraine and Russian Federation, and the dispute between Mauritius and Maldives over Chagos Archipelago. In fact, this dispute between Ukraine and Russian Federation is still pending. Therefore, I may not say much about that dispute. But anyways, I will briefly talk about this. This is South China Sea. It's very well-known dispute, right? Maybe you all heard about this dispute. This is South China Sea. It's not that far from Korean Peninsula. This is a well-known 9-dash line of China. You may find that there are 9 dash around here. But anyway, South China Sea is semi-enclosed sea of 3.5 million square kilometer, surrounded by 6 states: China, Philippines, Vietnam, and Malaysia, Brunei, Indonesia, and Taiwan. In South China Sea, there are several hundred maritime features, the dimension of which are not clearly known, but there are several hundred maritime features. The most well-known is so-called the Spratly Islands, which is located in the southern part of South China Sea. If I may go back, no. So this is Spratly Island here, Spratly here. There are several hundred of these features over which there are sovereignty dispute between the states. As you see, China up there, and Vietnam and Philippines. These three countries have kind of longest coastline, so they are main disputants in South China Sea dispute. And South China Sea includes crucial shipping lanes. It is also rich fishing ground. It has a huge potential for oil and gas, and there are abundant coral reefs, biodiversity. So it's a very important seas. Now, South China's dispute, there are 6 disputants. As I said, major disputants include China, Philippines, and Vietnam. There are sovereignty disputes over these hundreds of features, islets, rocks, and so on. There are sovereignty disputes. In fact, China claimed that all those features in South China Sea belong to China. Vietnam makes the same claim. Vietnam claims that all those features belong to Vietnam. Philippines makes a similar claim. Philippines claims that most of features, not all, but most features belong to Philippines. So you see already these 3 states claim sovereignty claim to hundreds of features in South China Sea overlap. So you see that sovereignty disputes. Then, of course, there are maritime disputes, maritime boundary disputes, fishery disputes, oil and gas disputes, overflight disputes over overflight, marine environmental dispute, marine scientific research dispute, disputes over military activities, and so on. So many kinds of dispute, many disputants, including sovereignty dispute, how sensitive a sovereignty dispute is. these are, you can see, very complex dispute. In addition, there is strategic dimension as well. United States maintains military presence in this part of the world, whereas China, as a rising power, challenged United States and so on. So then in 2009, China sent a note of avowal to United Nations Secretary General with a map. This is the map. In fact, this is the map China sent to UN Secretary General, in which you see this 9 dashed line. According to China, all these features within 9 dashed line belong to China, and so on. So it really triggered the dispute over South China Sea. As you see, this 9 dashed line includes not 100%, but almost 90% of South China Sea. Then in 2013, Philippines initiated arbitration against China under United Nations Convention on the Law of Sea. This United Nations Convention on the Law of Sea is often called UNCLOS. UNCLOS contains very strong dispute settlement mechanism. Under UNCLOS, state may unilaterally start legal action against another state. That is what we call compulsory procedure, compulsory jurisdiction, procedure. So Philippines utilized this compulsory procedure to start legal action against China with respect to validity of 9 dash line, which I just showed you, and the legal status of maritime features claimed by both China and the Philippines, and the legality of certain activities of China, especially China's artificial island construction activities in South China Sea. On 2015, arbitral award arbitral tribunal rendered its award on jurisdiction and admissibility, and next year rendered award on the merits, by which arbitral tribunal, in fact, found that Philippines' claims are valid. So, in fact, arbitral tribunal vindicated Philippines in most claims. Then China refused to participate in the proceedings, also refused to comply with the decision, although decision is legally binding, and so on. So even after arbitral award, dispute continues. And in fact, since 2023, after change of government in the Philippines, the situation has worsened. In fact, over the past 2 years, there has been quite a serious confrontation between Philippines and China in various parts of South China Sea. So what has been the contribution of adjudication to South China Sea dispute? It may be premature to say adjudication was not very helpful in resolving this dispute. But so far, there has been no constructive development relating to this dispute. Now, next dispute I just want to briefly introduce is this Crimea dispute and adjudication. This is, as I said, currently pending arbitration. I currently serve as president of arbitral tribunal over this dispute, so I may not say much, but I will just briefly introduce to you what happened is, this is a Black Sea, and you see here Crimea Peninsula here. Used to be, of course, territory of Ukraine until Russian Federation occupied it and made it part of Russian Federation's territory. Here, 2013 and 14, there was civil unrest in Ukraine between pro-Russian government. At that time, government in Ukraine was pro-Russian under President Viktor Yanukovych. And there was anti-government faction, pro-Europe, pro-EU faction. There was a civil unrest. Eventually, President Yanukovych government was overthrown, and Ukraine had this pro-EU government. Then, immediately after this political development, the Russian Federation occupied Crimean Peninsula, and there was a referendum on the future of Crimea, and Crimea declared independence, and Russian Federation and Crimea concluded the Treaty of Accession in 18 March, so Crimea became part of Russian Federation. After this accession treaty, Russian Federation started to exercise its right as a coastal state over Crimea. So it took over all rights and duties of coastal state in relation to waters adjacent to Crimea. For example, Russia Federation now exclusively control over fishing around Crimean Peninsula. It also took over all these oil and gas development platforms, drilling rigs from Ukraine. And so it exercised control over waters around Crimea. Then in 2016, Ukraine initiated arbitration under the Law of Sea Convention, UNCLOS, just like in South China Sea, against Russian Federation with respect to coastal state rights in the Black Sea, Sea of Azov, and Kerch Strait. So Ukraine's argument is Crimea belongs to Ukraine, and the Russian Federation unlawfully occupied Ukraine. Therefore, Russian Federation's control over waters around Crimea was also unlawful. So arbitral tribunal was asked to declare that Russian Federation's action relating to waters around Crimea was unlawful. And then Russian Federation raised objection to the jurisdiction of arbitral tribunal that Crimea is under dispute. There is a territorial sovereignty dispute over Crimea. Therefore, arbitral tribunal has no jurisdiction to determine sovereignty dispute. So that objection was raised, and eventually 2020, arbitral tribunal decided that it had no jurisdiction to deal with many of Ukraine's claim because obviously there is a dispute, territorial dispute over Crimea. In fact, the arbitral tribunal, which was created under Leipzig Convention, cannot deal with a territorial dispute. Therefore, it has decided to that it lacks jurisdiction to deal with many of Ukraine's claim. However, Ukraine's claims relating to legal status of Sea of Azov and Kerch Strait continues even now. It's as I said, it is still pending. But then, of course, February 2022, Russia invaded Ukraine, and right now, not only Crimea, but the entire coastal area surrounding Sea of Azov here, entire coastal area surrounding Sea of Azov, such as this Donetsk region, Zaporizhia, and Kherson region have been under control of Russian Federation. So there has been a lot of political development. Again, I'm not the one to say this, but one can wonder whether this education has helped to settle, maybe manage, let alone settle, this difficult dispute between Ukraine and Russian Federation. Finally, just briefly, this Chagos dispute. This is Indian Ocean. This is Mauritius, and that is Maldives. You may know that Mauritius, Maldives are popular destination for honeymooner, but that is not the entire story. There is a difficult dispute, and Maldives, Mauritius, and there is this Chagos archipelago, very small islands in the middle of Indian Ocean. This is a strategically very important location. Let me just briefly talk about the background of this dispute. In 1814, Mauritius used to be a French colony, but after a defeat of Napoleonic War, France ceded Mauritius to UK. So UK was the colonial power over Mauritius for 150 years, from 1814 to 1965. 1965, Chagos was part of Mauritius, although it was really far, far removed from Mauritius' main island. But Mauritius, Chagos was part of Mauritius. And what happened in 1965, the United Kingdom detached Chagos from Mauritius and made Chagos as a separate British colony called British Indian Ocean Territory, BIOT. Then United Kingdom and the United States agreed to build a military base in Chagos, especially in island called Diego Garcia. So this military base is still there. And in 1968, United Kingdom granted independence on Mauritius. Then since 1980, Mauritius started to claim sovereignty over Chagos. according to Mauritius, United Kingdom unlawfully separated, detached part of Mauritius territory, Chagos, from Mauritius before it granted independence to Mauritius. And so there was really a dispute between Mauritius and UK over Chagos. United Kingdom continued to maintain control over Chagos. On the other hand, Mauritius tried to take Chagos back from United Kingdom. By the way, this Chagos, or British Indian Ocean Territory, was the last colony of United Kingdom in Africa. Then in 2017, this Chagos matter has been very controversial issue for many years, especially in the United Nations General Assembly. So in 2017, United Nations General Assembly requested the International Court of Justice for an advisory opinion concerning decolonization of Mauritius. Whether this United Kingdom's action to separate, detach Chagos from Mauritius before granting independence to Mauritius was lawful in terms of international law on self-determination and decolonization. And 2019, International Court of Justice gave an advisory opinion to the effect that process of decolonization was unlawful, and the continued administration of Chagos by United Kingdom constituted wrongful act of continuing nature. Then 3 months later, in May 2019, United Nations General Assembly adopted a resolution endorsing advisory opinion of ICJ and asked United Kingdom to return Chagos to Mauritius 6 months after this General Assembly resolution. United Kingdom refused to do so, and September 2019, Mauritius started legal action against Maldives, not UK, Maldives, about the delimitation of maritime boundary to the Special Chamber of International Tribunal for the Law of Sea. I was involved as a president of Special Chamber. Then 2021, Special Chamber gave its judgment on preliminary objection that for the purpose of this delimitation, Chagos can be considered as part of Mauritius. So Special Chamber of ITLOS endorsed advisory opinion of IC. This may be true for even the case of highly complex, politically sensitive dispute. So I would end my lecture. International law is necessary and important, not to transform the nature of international politics or relation, but to maintain certain minimum international order in decentralized world. So especially today, we are living in a quite challenging time for international legal system, but we shouldn't lose our faith in the constructive role international law and international adjudication can play. I think I will stop here. Contrary to what I said, I think we are running out of time, but I hope you have enjoyed this class. Thank you.
Thank you. As we expected, he taught us about the details of the distribution mechanisms in the international society, referring to several cases that he has been involved personally. It was a very good chance for the students and other audience to understand about the international dispute settlement mechanism. Once again, let's give a big round of applause. And I understand that some people may want to have questions. So I also understand that some others may have another sketch to go. So after he finishes his lecture, he will stay here for some minutes. So if you have any questions, you can approach the podium, so then you can have a personal chat with Professor. And then finally, I would like to give my special thanks to Professor Kang Kyung-gun from the law school. Also, His Excellency Ong, who was the former Deputy Minister of the Ministry of Justice, for this special lecture today. So thank you very much. I would like to formally conclude today's special lecture. Thank you very much.